We are at the Supreme Court of the United States of America doing a law vlog that is totally funny. You should mention that. This is an absolute first for us. We are at the actual Supreme Court of the United States of America, and there seems to be something going on behind us. We're going to be doing a law vlog about a Supreme Court decision that was just heard about a week ago involving a trademark dispute over the brand Fuct, or as I choose to pronounce it for the sake of this family phone.
Daddy, the bird's making his nest.
There's a bird making his nest on the Supreme Court? Impossible.
Lloyd, look up.
Oh wow, that's pretty cool. As I was saying, pertaining to a trademark over the brand Fuct, or as I choose to pronounce it because this is a family-friendly channel, Fuct.
I need to go to the bathroom.
Let's go inside, people. The case that was heard by the Supreme Court relates to a clothing brand aptly named Fuct, F-U-C-T, not pronounced that way. And the Supreme Court is being called upon to adjudicate as to whether or not that brand is able to be trademarked and whether or not the USPTO, United States Patent and Trademark Office, were justified in initially refusing to grant a trademark to the term Fuct. Yes?
Can we go to the cafeteria and get something to drink?
Yes.
Is there a gift shop anywhere?
There is a gift shop actually right over there. Excuse me, am I allowed sitting on the base of that statue? No. Okay. Before we get into the details of the specific case, let's just talk about trademark in general. It's one of those words like copyright that most people don't actually think about on a day-to-day basis, but copyright literally is the right to copy a work of somebody else, hence copyright. Trademark is literally a mark associated with a specific trade. Usually it's a word or combination of words associated with a good or service. Nike with shoes, Adidas with shoes, Nikon with cameras. Boy, there's a lineup for the cafeteria. In the United States, it's the USPTO, the United States Patent and Trademark Office. In Canada, it's called the CIPO, the Canadian Intellectual Property Office. And it's a little known fact that in order to... Sorry? Oh, me. Oh, it's a vlog. Should I not do it? Okay. I was asked not to vlog quite so openly. I'll do it more discreetly. I don't ask questions with security officers. Okay, so the deal is that the administrative tribunal that grants or refuses trademarks can grant or refuse a trademark on a number of what?
So you're just going to do this and pretend that we're all listening?
I'm just going to do this. No, she said just, don't lay on the ground and talk in front of the statue. USPTO and the CIPO grant or refuse trademarks, and they refuse them on a number of criteria that a lot of people don't necessarily fully appreciate. They can refuse a trademark on the basis of it being too generic to be a trademark. Apple is Apple's not a good example because Apple is trademarked with respect to computers. Whatever. What does generic mean? Just like a common word, the. Although that's also a bad example because you can take a common word and then make it specific to a brand of something. Get out of here. Okay.
How about floor?
Floor? I don't know. Bench. You have bench for purses. If I wanted to trademark a shoe and call it shoe, it would be refused. But if I wanted to trademark, let's just say, a microchip.
How you doing, my friend?
There's business going on behind us.
All right, good deal.
I'm not going to be able to vlog in here because of the noise, but look at that chandelier right above my head. I look like a king. The king of vlogs.
That's kind of cool.
All right, we will carry on this conversation about trademarks somewhere else. All right, now we are in the Supreme Court gift shop.
For Granny?
We should get that for Granny. Go give it to Mom. The Supreme Court has a gift shop. Okay, just to finish what I'm talking about on rejecting trademarks. If the terms are too generic, like bag for a bag, like apple for an apple, the trademark office can refuse to grant a trademark. There are other exceptions as well. If you are referring to a geographic location, your trademark can be refused. Beaujolais, for example, is a reserved mark that can't be used by just any wine company. Proper names are often refused by trademark because can you imagine living in a world where some other person can't use their proper name because it's been trademarked by someone else with the same name? Flags and official marks can also not be trademarked. And then we get into obscenities. How's it going? Or scandalous trademarks. Guess which one Fuct falls under? We are leaving the Supreme Court of the United States. Now, under the Lanham Act, also known as the Copyright... Okay, under the terms of the Lanham Act, also known as the Copyright Act of 1946, scandalous marks will not be granted trademark by the Trademark Office. Fuct was deemed to be scandalous by the USPTO. These are beautiful fossilized turtles. Very rare, very well preserved. You can even see the beak on them. Look at that, amazing. Oh, there's a mug here. That's a security hazard.
I want to see
Supreme Court judge's mug.
Under the terms of the Lanham Act, scandalous or offensive marks will not be granted trademark. And that's exactly what happened to Fuct by the USPTO. They did not grant a trademark over the term Fuct in relation to brand clothing, apparel, whatever.
You guys aren't walking.
The Patent and Trademark Office deemed the term to be obscene, scandalous, offensive, and thus refused to grant a trademark on it despite it being in use since the early 1990s. The brand appealed the decision and they were still rejected, but what ended up happening in the interim was that there was a Supreme Court decision in the case of the trademark for an Asian American rock band called the Slants. That term, the Slants, was initially deemed to be offensive and scandalous by the USPTO and the trademark was refused. They appealed the decision up to the higher courts and the Supreme Court of Canada and the United States Supreme Court determined that it was a legitimate trademark and they granted the trademark to the term the Slants for the Asian American rock band. That is the backdrop under which the United States Supreme Court just heard this most recent case for Fuct. And they are going to be called to determine whether or not it is scandalous and offensive enough to the point where the USPTO can refuse to grant a trademark on the term. We can carry on the rest outside. Well, that's not the end of the vlog. We can carry on the rest of this not necessarily in the vicinity of the Supreme Court. Setting aside the whole legal aspect of this discussion, can you imagine spending an entire day in the Supreme Court where they are adjudicating on an issue where they can't even say the main word? From the articles I've been reading, it was like a whole dance as to how they tiptoe around the actual brand that they're trying to discuss whether or not should be granted a trademark. Some of the examples of offensive terms that have been granted trademark: FUBAR, which stands for Fucked Up Beyond All Recognition; FCUK, which looks like the word Fuc, except it's French Connection United Kingdom, purportedly. The word crap has apparently been registered in 70 trademarks, whereas the SHIT word has never been granted a trademark. So the question becomes, what words are objectively too scandalous, shocking, offensive to be granted a trademark, and which aren't? Because apparently there is little logic, rhyme, or reason as to how the USPTO has been granting trademarks on borderline offensive terms. It's going to be an interesting decision to follow because if the trademark is granted on the brand Fuct, it's going to open up a floodgate to variations of spellings of otherwise objectively offensive swear words. And then the question is going to be, where is the line going to be drawn in the future? Is it just going to be a slippery slope to the point where all offensive, degrading, horrible terms are going to be susceptible of trademark? My prediction. Good yourself.
Heads up, no tripods allowed on Capitol ground.
Okay.
You can do it in the grassy area if
Okay.
you like. But
I'll go finish. I have 30 seconds left anyhow.
sorry about that.
All right,
I was
don't.
trying to let you finish. But I didn't know
No, it's good. Thank you. Very interesting. No tripods on federal ground. Anyhow, I was almost finished, so we'll just go wind this up on the grass under a tree. Should be beautiful. My prediction, bear in mind I've been wrong in the past and I'll be wrong again in the future. I am predicting that Fuct is not going to be granted a trademark. And the reason why is because this will invariably open a floodgate to variations of spelling of otherwise offensive and obscene words. And what's the difference between Fuct, FUBAR, FCUK, and the Slants? FUBAR is an acronym that in and of itself is not an offensive term. FCUK is a visual play, but is not itself a word, although I have never believed for a minute that it was actually intended to be French Connection United Kingdom, but that's just me. And the Slants is not in and of itself an offensive term. Slant is a word that has a meaning. It can be disparaging in certain contexts, but it is not objectively and standalone an offensive term. Fuct is just an alternative spelling to an objective, well-known, well-established swear word, possibly one of the worst swear words on earth. And I suspect that the Supreme Court might actually decide that it is not a First Amendment issue because nobody is depriving the brand of using the term Fuct. They are just being deprived of registering it as a trademark. They are being denied commercial protection, not freedom of expression. But I am not infallible. I am frequently wrong. Regardless, now you know your vlog. Peace out. Oh, did I forget the whole most important thing? If you like my content, like, share, and subscribe. And I forgot to introduce myself. I am Viva Frei, a Montreal litigator turned YouTuber. If you like this content, like, share, subscribe, hit that notification bell. Now you know your vlog. Peace out. Boom.